beat the coronavirus, and we will beat it together. And therefore, in this moment of national emergency, I urge you to please stay at home and practice social distancing to protect our NHS and to save lives. Thank you.
We are now preparing to a nationwide lockdown in the same ways as other countries do. Staying at home is essential. If you have any questions on what you can or can't do, just apply a principle. Act like you have COVID-19. Every move you make is a risk to others. Thank you.
Utama kerajaan kita pada masa ini ialah untuk mencegah penularan wabak baru ini yang dikembangi akan menjangkiti lebih banyak rakyat. Jadi, kerajaan memutuskan Perintah Kawalan Pergerakan memulai 18 Mac 2020 hingga 31 Mac 2020 di seluruh negara. Duduk di rumah sahaja, jangan ke sana ke sini.
Kesana, kesini, kesana, kesini, kesana, kesini, kesana, kesini.
Hi, my name is Lai Jing Yi. Administrative law can be taught as a subcategory of constitutional law, as it is to a large extent complemented by constitutional law. Although there is no universally accepted definitions of administrative law, rationally, it addresses the powers, duties, functions of public authorities of all kinds engaged in administrations, their relation with one another and with citizens and non-governmental bodies, legal methods of controlling public administrations, and the rights and liabilities of officials. Per Edit Court, the core of administrative law is the provisions of processes independent of the government for the prevention of government actions that can be identified as arbitrary with no breach of committee. Regardless of the source of executive's decision-making power, safeguards against misuse are necessary. In different countries, governmental actions are scrutinized by different legal safeguards. The United Kingdom's position is, as it always has been, the most effective when the control of the executive and administrations can and should be exercised in ways complementary to judicial review. Judicial review is a process by which the courts control the exercise of governmental power, ensuring government departments, local authorities, tribunals, and state agencies are exercising powers in a lawful manner. The purpose of administrative law was expressed with different views by administrative law theories. Harlow and Rawlings categorized administrative law into the renowned red light and green light metaphors. Each color represents a different theoretical approach to the functions of administrative law. Both theories have opposing views in terms of the purpose of administrative law, powers and duties of the executive and public body, and the extent to which the court should intervene in public law disputes. The red light theory considers administrative law as a means by which state activity are controlled and protections of individual rights are provided. By contrast, the green light theory holds the perspective that administrative law facilitates the operations of the state rather than controlling it. In recent decades, the amber light theory, which occupies a relatively intermediate positions between the red and green extreme, emerged. Some call this the traffic light analogy, but now this is not the ordinary traffic light you thought. The rights-based approach advocated by Sir John Laws, which elevates the court's constitutional role to safeguard human rights, shares similar attribute with this theory.
Hi, my name is Liew Lok Yee. I will explain about the red light theory. Red light theories posited that the exercise of governmental power should always be controlled by the courts and precluded from interfering with individual rights. They recognize the objective of administrative law as a means to control the excesses of government power to safeguard individual liberty. It is called the red light theory because it shows red light for administrative interventions and emphasis on judicial control by maximizing the interventionism of judicial review. In the United Kingdom, this theory was speculated to apply before the Human Rights Act 1998, which paved the way for review of the proportionality of action which prima facie infringes human rights while entails merits review. Based on this theory, the best form of government is the one that governs least. The wider power might imply threat to the citizens' constitutional rights and liberty. Red light theorists believe that law was autonomous to and superior over politics. Therefore, the law must provide means to control the administrative powers so that the public authorities exercise their powers within their legal bounds and prevent them from running amok. Central to this theory is the concept of rule of law, whereby courts are the main weapon to protect the individual rights and to control the exercise of executive power. The red light approach is traced back to Professor Dicey and a political tradition of 19th century laissez-faire, the minimal state interference theory that embodied a strong suspicion of governmental power exercise by emerging state bureaucracy as central or local governmental power. Dicey asserts that administrative law restricts what the government can do. The red light theory has been tied in with Dicey along the insistence of the rule of law. This theory exemplifies the constitutional principle of the rule of law, which promotes the postulates of no man can be punished unless there's a clear breach of law, equality before the law, and our rights are safeguarded by common law. If the government's unlawful actions infringe the rights of individuals through an illegal, irrational, or procedurally improper decision, the executive will be subjected to legal control by the courts. Therefore, protecting the rights of individuals would uphold the rule of law. This theory is illustrated when a decision is challenged by means of judicial review on the grounds of illegality. If the executive decision maker exercises delegated powers beyond those conferred by Act of Parliament, the decision will be invalidated because the Parliament did not authorize the power exercise. Hence, this theory ensures the will of Parliament is enforced and thus be considered as an aspect of parliamentary sovereignty. Weil denoted that a balanced constitution where executive power is consistently subjected to checks and balances by both Parliament and the courts is a variant on the separation of powers. Under the separation of powers framework, the courts are granted judicial power to review on the government actions. Red light theorists believe the ultra-virus rule is the foundation of judicial review as it promotes a strong role for the courts to review ultra-virus administrative decisions when the executive exercises their power outside of the powers conferred. Therefore, when there is an ultra-virus decision which interferes with the rights of individuals, the red light theory will play the heroic role to safeguard the individual's rights. It is not surprising to find many administrative theorists who are inclined that the red light theory aims to control any excess of government power and subject it to judicial control. Based on the theory of separation of powers, the court must not interfere with the discretionary power of executive conferred upon by Parliament. When discussing the red light theory, the word control in the context of judicial control can be symbolic or real. It can mean to check, restrain, or govern. In the case of Pat Phil against Minister of Agriculture, Fisheries and Food 1968, the court did not substitute the decision made but issued a mandamus order wanting the minister to reconsider whether he should exercise his power to refer the matter. Therefore, the main concern of the red light approach to judicial review is the manner in which decisions are being made, but not the merits of a particular case. The controls are therefore external and indirect, as it doesn't affect the decision made by the executive. Thus, this theory is not to affect the executive power, and the separation of powers are still being upheld.
Hi, I'm Zhi Chen. So now I'll talk about the green light theory. The aforementioned red light theory focuses on the regulation of power and security of individual liberty and takes the view whereby the state needs to be constantly kept in check by the court rule-based adjudication. In contrast with the red light theory, whereby law is superior to politics, Adam Tonkin states that under the green light theory, law is just a rather elite discourse of politics and is neither above politics and administration. This theory highlights the question of law relationship specifically with public administration. The green light perspective is based on an acceptance of a social democratic view of the state and regards law as an essential tool for the delivery of communitarian policy objectives. It originates from the utilitarian tradition of egalitarian and ameliorative social reform. Accordingly, this theory contrasts with the red light theory in the sense that the courts appear to be more liberal and purposive in construing statutes in the former approach, and are more literal in the latter. Tonkin takes the view that public administration is not a necessary evil to be tolerated, but a positive attribute to be welcomed. Similarly, Hilary Bennett stated that administrative law as a vehicle for political progress and welcome the administrative state, whereby good administrative practice should be facilitated rather being controlled. Administrative law should focus on seeking good government through the political process and public avenue rather than redressing bad government through the court. The ideal way to achieve this is through political check, such as accountability through parliament and ministerial supervision, not through lawyer and adjudication of the court. Green light theory is concerned with establishing to a greater extent the notion of political accountability and permitting the state to develop its policy agendas and not to removal of the rights of individuals or ignorance of any ideals from the democratic society, with the main goal being enhancing and facilitating state activities. This theory thus regards political involvement of the court as an obstacle towards potency. This theory also prioritizes the enhancement of individual and collective liberty by providing minimum standard of provision such as housing support, education, health service, and other local services. The response from electors to accountability issues has not been to rely primarily on the court for redress, but not to build into a decision-making process of certain rights and a degree of participation by the citizen. An application of this theory can be portrayed by the parliamentary ombudsman who reports his investigation regarding complaints toward the government to the Select Committee of the House of Commons. A redress would be provided for the complainant by the said department via apologies or monetary compensation. The evidence from both the department and ombudsman will then be taken into consideration by the committee to correct and improve the unsatisfactory administrative practice. Tribunals might be regarded as the archetypical green light remedy because of their ability to deal with a large throughput of cases speedily and informally. Until recently, tribunals tended to be relatively specialized body custom designed by individual statute to perform a particular adjudicative function in respect to an area of administration. The green light theory is stated to represent the position of Singapore, although Harlow and Rollins suggest that the theories are only descriptive models. However, in the Singapore case, J.R. Redmond, Kenneth Andrew, and Attorney General, the court not only declared that the green light theory has been said in another cases, which is Belama Marie and Otto General, to represent the situation in Singapore, but also proceeded on the basis that it should be prevailed.
Hi, I'm Ying Chia. I'm going to explain the rights-based theory, which makes up the third administrative law theory to be focused upon in this video. Sir John Laws outlined in his works that this approach focuses mainly on the court's role to serve as a safeguard for fundamental rights and constitutional rights through judicial review. It also postulates a higher order of law which binds the government. It's the criticisms of the ultra-virus model, which sets forth a pursuit for an alternative source of authority for judicial scrutiny of executive decision-making. Hence, a higher order law emerged in the United Kingdom and justified the increased involvement of judges in executive decision-making. According to Sir John Locke, there are certain limits which democratic governments should not overstep. Such limitations were the essence of the higher order law. The need for a higher order law is determined by the logic of the very notion of government under law, whereby any government holds office by virtue of a framework of rules which define the institution of government. It is necessary for a higher order of law to be formed and enforced by the judiciary. This is to ensure that the fundamental sinews of the Constitution, the cornerstones of democracy and inalienable rights, are guarded by the unelected and unaccountable courts instead of falling into the control of democratically elected and accountable government. This approach is often based on a specific conception of liberalism and individual autonomy, with a distinction drawn between positive and negative rights. Bowles and Red theory, which was conceded by Harlow and Rawlings, suggests similar attributes with the rights-based approach. This is because both theories elevate the court's constitutional role in safeguarding human rights. Similar to the red light theory, the rights-based approach regards the law as distinct and superior to politics. Both approaches uphold the rule of law through judicial review. Nevertheless, the substantive conception of rule of law has far more extensive implications in the rights-based approach than the red light theory. As an illustration, although both approaches compel the courts to scrutinize unlawful decisions made by the executive, the meaning of unlawful in both contexts differ considerably. In context of the red light theory, where judicial review is said to be strongly grounded on the ultra-virus rule, unlawful meant that the executive has exercised their discretionary powers beyond the powers conferred upon them by the parliament during the decision-making process. Whereas, in context of the rights-based approach, the executive is deemed acted unlawfully when one's rights are violated unjustifiably. In the latter situation, the court only intervenes to control decisions when the discretion has an impact on what the law regards as a constitutional or fundamental right. Hence, it is evident that in the rights-based approach, the rule of law is the foundation by which certain rights could be derived from. It may be observed that the rights-based approach is embodied to a great extent in the United Kingdom. Although it only emerged analogous to the expansion of doctrine of ultra-virus and been robustly used after the incorporation of the European Convention on Human Rights by means of Human Rights Act 1998 in domestic law, the United Kingdom has been at the forefront of protecting human rights since the formation of the Bill of Rights 1689. The increased resort over the last decade to human rights in judicial decision-making following the incorporation of the Convention rights has shown a pressing need to encourage a more comprehensive understanding of the role of rights in contemporary public law. The scope of judicial review was expanded by which domestic courts could scrutinize any alleged violation of the Convention rights by public bodies rather than just the legality of the decisions. The long-standing doctrine of proportionality adopted in Strasbourg was then embraced by domestic courts. This doctrine formed an additional basis to the three conventional grounds of judicial review as laid down in the GCHQ's case for the test of legality of public authorities' actions. The doctrine of proportionality deliberates the objective of the decision maker and determines whether the means to which that objective was achieved was proportionate. In Delhi against Secretary of State for the Home Department 2001, Lord Bingham stated that although the decision had been drawn on the basis of common law, the same results could have been obtained if the evaluation had been carried out on the basis of convention rights. Thus, it is clear that the House of Lords judges are willing to expand common law principles to align them with the European concept of proportionality. To summarize, the rights-based approach is being embraced in the United Kingdom, whereby the protection of fundamental and constitutional rights of citizens are enshrined via judicial review. Thank you.
After analysing the red, green light theory and the rights-based approach respectively, we shall move on to the next part of the video. The rampant spread of COVID-19 has caused an ongoing global health crisis, whilst capsizing communities and economies around the world. Being in uncharted waters, each state faces unprecedented challenges, with the crisis putting state capacities to test more effective countermeasures than the constitutional arrangements made available in times of normalcy are required. Therefore, the effectiveness of the management of the COVID-19 outbreak greatly relies on applying the relevant administrative approach.
Quoting the Secretary General of the Council of Europe, Maria Pejinovic-Burek, "The virus is destroying many lives and much else of what is very dear to us. We should not let it destroy our core values and free societies." Having said that, it is arguable that striking a balance between assuring the responses to the threat posed is proportionate and taking fast actions to curb the spread of the virus in a very limited time is almost impossible.
States that adopt the red light theory, which reflects the distrust of those who wield executive power to a great extent, relies heavily on a constitutional check such as judicial review. Nevertheless, during dire situations, the constitutional checks may obstruct swift governmental actions. There is a crucial need to recognize that the government had to take swift and decisive actions when the lives of the whole nations are on the line. In states that are inclined to the right-based approach, safeguarding the citizens' rights has always been the primary concern. The states are expected to operate in a way that their long-serving core values, such as fundamental rights and the rule of law, are being respected at all times. However, it is inevitable that the measures and responses taken by the states during the exceptional crisis can result in the encroachment of human rights and liberty that are integral to a mature democracy. The UK had taken a different approach to the COVID-19 at the onset of the outbreak as compared to other countries. Unlike China, Singapore and Malaysia, the government only advised their citizens to practice various voluntary constraints, such as practicing self-quarantine if symptoms are exhibited and the social distancing, instead of declaring a lockdown to restrict movement and liberty. By imposing only voluntary restrictions, it is speculated that the UK aimed to minimize the interference with the human rights. Concerns over infringement of the right to liberty, right to private life, freedom of assembly and movement stalled the government from implementing strict government policies promptly. Also, at the early stage, the government did not have sufficient legal authority to impose strict restrictions. Later on, the soft confinement measures had been withdrawn as the citizens refused to comply with it. The failure to give sufficient considerations to impose restrictive yet effective measures during the initial stage caused the exponential spread of the virus. The priority of the states should be focused on averting the virus as soon as possible rather than formulating policies that protect each fundamental rights. To adopt with the crisis, emergency measures that are strictly necessary but might not be allowed by the state's constitutional arrangements during normalcy are required to safeguard the functioning of the state and the protection of its people. Rights such as freedom of movement and assembly should be compromised temporarily as seen in the country adopting the green light theory. For instance, New Zealand started one of the most strict measures in the world, namely to quarantine all the travellers even though there were only 6 cases nationwide, and announcing a total lockdown after a month since the country recorded their first case. The country had now succeeded significantly in terms of breaking the chain of transmissions. Several issues pertaining to the clarity of emergency legislations which introduced temporary measures to alleviate the pandemic impact on the frontline workers, arose. The Health Protections Regulations 2020, which granted broad police powers, was criticised due to its vagueness. Ex-Supreme Court Judge Lord Sumptions forewarned the risk that the UK might become a police state after a string of cases whereby policemen have been accused of being overzealous in their powers to enforce the will of ministers. In light of the incidents, guidelines requiring officers to police by consent, by stressing the risk to public health and NHS, to encourage the public to comply with the lockdown and practice social distancing voluntarily, were issued by the College of Policing and National Chiefs Council.
Next, the Coronavirus Act 2020, which is said to have the most sweeping power ever taken by the UK government, outside the wartime, fast-tracked by the Parliament, broadened the power of government officials, including police, health, immigration officer, allowing them to detain potentially infectious persons, interfering with the right to liberty and assembly. As a result, citizens resorted to the court for judicial review. By striking out of such executive decision on the grounds that the wait provision violated such rights, the courts undoubtedly interfere with the government urgent policy responses to halt the spread of COVID-19. Besides, the tracing of infected persons was ineffective as the UK government had concern on using the NHS COVID-19 contact tracing application, which impedes the rights to privacy due to the usage of huge amount of personal data during tracking process of infected people and those who were in contact with them. Therefore, this measure was still at a trial phase starting May. Meanwhile, without such interest, the Malaysian government has been actively monitoring those with COVID-19 and whom they might have been in touch with since first transmission of the outbreak by contact tracing and detection. Amid public health emergency, administrative law should cater to honor a green light theory of government, demanding efficient delivery of public function with an unquestioned presumption that government is serving public needs. Legislating board provisions are inevitable as legislative proceeding must be a brief and fast-tracked. Executing COVID-19 responses is the matter of greater importance in order to safeguard the survival of the state and people. During crisis, courts should apply statutory interpretation in a way that confers the widest power on government that the world will be reasonably bear. It is insensible to expect the government to base its lockdown provision on clear and unambiguous statutory authority in urgency. Excessive judicial scrutiny may undermine the execution of public function. Anyhow, the executive should remain untouched.
To conclude, administrative law must transform its focus from red to green light, from restriction to empowerment, and from formality to flexibility. In light of the issues that arose in the United Kingdom, it is suggested that the rights-based approach and red light theory appear ill-suited for managing the pandemic. The green light theory would be the most relevant theory in combating the virus with resilience, as proven by the countries that have successfully flattened the curve. The refusal to take draconian measures to limit the freedom of its citizens at the onset, in fear of violating their human rights, caused the United Kingdom to suffer from more than 248,000 confirmed cases and significant economic recessions. The compromise of human rights may be justified, as the quicker the government responds, the earlier the country can move on to the recovery stage. Although the new norms may differ from the norms enshrined in the constitutional arrangement of the country during times of normalcy, they are necessary to enable the executive to gain more powers to respond efficiently to this crisis. Thank you. This is the end of this video. Thank you for watching Taylor's News.